Well, good morning there. It's not really morning, but hey, I can say morning, can I? Sorry, guys. We're going to be talking about the ABCIP, a Delaware limited liability corporation, Rare Breed Triggers, a Texas corporation, First Peak Tactical, which is doing businesses as Partisan Triggers. You probably know Partisan Triggers. They are located in Wyoming. Peak Tactical is the parent company. The DBA is Partisan Triggers. And Rare Breed has been suing Partisan Triggers, and they tried to get a restraining order, a temporary restraining order, and also a preliminary injunction against Partisan, and basically shut the doors on Partisan so they couldn't make their Partisan disrupt their trigger. And I'm here to say, unlike in the Hoffman Tactical case, Rare Breed failed. And I saw this coming because the Partisan lawyers are just better, and their expert witnesses are just better. I mean, it was like a professional sports team playing against a elementary school team, and we got the results. So I'm gonna go ahead and bring this up. Stambo, if you're wondering when Stambo is gonna be doing his video over at 2A Law, he is on a plane right now. He might be doing it tonight when he lands, but he's not exactly sure because all he has is his laptop. He is going to Florida. All right, so let me go ahead and read this through here. This is a order denying plaintiff's motion for temporary restraining order and preliminary injunction. ABC IP LLC and Rare Breed Triggers Inc. plaintiffs brought this action against Peak Tactical LLC, DBA Partisan Triggers, and its owner Nicholas Norton, the defendants, for patent infringement, false markings, and advertising. Both parties make and sell firearms triggers. Plaintiffs assert defendants' triggers design infringes on 4 of its registered patents. On January 16th, 2026, plaintiffs filed for a motion for a temporary restraining order and preliminary injunction. The court issued an order requiring plaintiffs to serve the complaint and motion on defendants by January 23rd, 2026. The order also required defendants to respond to the motion by January 30th, 2026, and an in-person hearing was held on the motion on February 4th, 2026. After careful consideration of the briefings and arguments offered at the hearing, this court denies the plaintiff requested relief. Plaintiff ABCIP, ABC, and Rare Breed Triggers, RBT, brings claims of patent infringement, false patent markings, and false advertising under the Lanham Act against defendants Peak Tactical LLC and Nicholas Norton. Plaintiff's claims are based on 4 patents they hold related to force reset triggers. A FRT is an aftermarket firearm trigger that operates by mechanically resetting the trigger after each shot, allowing the user to make faster follow-up shots without manually releasing pressure on the trigger. ABC owns 4 patents generally related to FRTs that can be retrofitted into existing semi-automatic rifles. They asserted U.S. patent number 223 003 336 807, collectively known as the asserted patents. ABC exclusively licensed the asserted patents to RBT, whose designs, manufactures, and sells aftermarket triggers, including the FRT 15 L3 trigger. Plaintiff alleges defendants have committed willful acts of direct contributory and induced patent infringement in violation of 35 USC section 271. The defendants manufacture and distribute the Partisan Disruptor, an aftermarket FRT trigger Except for minor inconsequential cosmetic features on the outer housing, plaintiff alleged the partisan disruptor is a direct copy of the RBT's FRT 15L3 that one of their distributors, Firearm Systems, sells for $299 to $150 or 33% cheaper than the RBT FRT 15L3. Plaintiffs allege the defendants have falsely advertised their disruptor by incorrectly describing it as a assisted reset trigger rather than a FRT. The plaintiffs further allege defendants have engaged in false advertising by telling the public that the partisan disruptor implements it and is covered by patent number 067. Patent 067 relates to an assisted reset trigger and was issued to Partisan's employee Michael Stakes before the asserted patents were filed. All right. I don't think I really have to explain too much of what's going on there. He's just basically breaking down what is going on. And from there, we're going to go on here. In this instant motion, plaintiffs request an entry of temporary restraining order and preliminary injunction enjoining the defendant's business operations and marketing. Basically, they wanted Partisan to shut down totally. So that's basically what that goes over there. Going to skip some of this. First, plaintiffs argued that the patent infringement claims are likely to succeed because it establishes that ABC owns the asserted patents and RBT is the exclusive licensee, that the accused disruptor meets all asserted claims and is a copycat of FRBT's FRT 15L3 patent implementing product. The defendants have never raised a substantial question of invalidity or enforceability despite being aware of their patent. Good luck, Steven. Talk about Steven. I was telling people to go check out your channel that you're going to be doing something later. He's on a plane right now. I'm going to mark I'll get to the questions in a little bit. Plaintiffs argue that their false advertising claims is likely to succeed on the merits because evidence establishes that Partisan willfully makes public false statements about the design and legitimacy of the disruptor to siphon RBT's would-be FRT 15 L3 customers. There you go. Next, plaintiffs claim they were suffer irreparable harm without the requested injunctive relief because price erosion, basically because Rare Breed is selling these at such a markup that they think that they're going to have to lower their prices, which they probably will, but hey, that's capitalism, right? Loss of market share, harm to its reputation, and loss of business opportunities. Plaintiffs go on to argue that the balance of harm weighs strongly in their favor. Particularly, plaintiffs allege that the defendant's actions threaten the long-term viability of their company, while defendants would not suffer any legally consequential harm in light of the fact that their actions sought to restrain are contrary to the law and would maintain the status quo. All right, one of the big things that a TRO or a PI is supposed to do is supposed to maintain the status quo. Rare Breed here was arguing that since they had the exclusive market on FRTs, that would be the status quo. Also, you can't really benefit from something that's like infringing. So if it's likely that it was infringing, then they're saying that they should get a TRO. And they're also saying they also want to say how that it is the public interest lies in protecting designs. Let's read the defendant's response. Defendants oppose plaintiff's motion for a TRO and preliminary injunction and request it be denied. Defendants argue the disruptor does not infringe on the asserted patents because it operates its operations do not satisfy several requirements in the asserted claim, and that plaintiff's evidence on this issue is conclusory and lacks substance. Defendants go on to argue that their 067 patent predates the asserted patent. They contend that the disruptor not only practices the 067 patent, but the plaintiff's FRT triggers infringes on their 067 patents. That would be bad for Rare Breed if the judge decides that Rare Breed is the one that's infringing on their patents, because that would basically mean all their patents are oath. In assessing the elements of a TRO, in a preliminary injunctions, defendants argue that the plaintiffs are unlikely to succeed in their patent infringement case. They argue that the certain patents are likely invalid because of the 067 patent, and insist the plaintiff patents require claim construction. Defendants go on to argue that the plaintiffs have not shown a likely infringement because the disruptor does not infringe on the asserted patents. The plaintiff's allegations are conclusory and lack necessary element by element analysis. The Rare Breed analysis, their expert analysis, was not the greatest. It was actually, yeah. But we're going to go on from there. Defendants also argued plaintiff's false advertising claims is without merit because the term assisted reset, forced reset, and positive reset are interchangeable descriptors for the same underlying cycling driven reset phenomenon. And the disruptor clearly practices claims 19 of the 067 patent. Defendants argue plaintiffs have failed to show irreparable harm because they delayed filing in this instant suit for 6 months after the disruptor was available for market, while filing 6 other lawsuits against dealers of the disruptor. Defendants also claim plaintiffs' own experts' analysis shows if plaintiffs are ultimately successful in their claim, money damages would be sufficient to account for harm. Now, irreparable harm means that it cannot be made whole by financial means. And also, what they're saying is that to get a preliminary injunction or TRO, time is of the essence. If you wait, the courts are going to say, well, if it was an emergency 6 months ago, why is it an emergency now? Defendants assert that the public interest does not file the injunction, such as one requested, and the hardship it imposed on the defendants if an injunction preventing the sale of the disruptor would serve would likely collapse their business, while any hardship to the plaintiffs is compensatable. What that means is if Rare Breed wins, they can be made whole by financial means. If Partisan gets shut down and they can't sell, they're going to go out of business, which means the business shutters, which means they cannot just spin it back up. All the employees would have to be laid off. They go to ground zero, and that would be irreparable harm. Last, the defendants argue that imposition of an injunction would necessitate a substantial bond to account for defendants' lost burdens. I mean, talk about they would like be in like the 8-figure sum to file a bond, and whoever gets it has to file a bond. All right, we're gonna go in here. Patent law is governed by the federal court, and regional circuit court laws applies procedural issues such as insurance of preliminary injunction relief. Okay, we're gonna skip a bunch of this here. And basically, Tarot is basically the same thing. So I just want to get down here. Yeah, they got the Hoffman. A Tarot ex parte nature and short duration represents its purpose to preserve the status quo between the parties and preventing irreparable harm until the court can rule on the merits of a preliminary injunction. The status quo is defined as the last peaceable, uncontested status existing between the parties before the dispute is resolved. In contrast, the preliminary injunction preserves the relative position of the parties until a trial on the merits can be heard. You got to remember, this is not on the merits of the case. This is just to remain the status quo. In both cases, however, injunctive release is an extraordinary remedy. This extraordinary remedy is not awarded by right. Basically, you have to prove that you deserve it, so you're not really entitled to it unless you can prove that you are. And we're going to get to why Hoffman might have not got his and Partisan has. The moving parties must demonstrate a substantial likelihood to succeed on the merits. The movement would suffer irreparable harm, and we already went through all that. But we're just going to jump down here to the ruling of the court. After hearing testimony and reviewing the briefings on each of the 4 preliminary injunction factors from the party, the court finds each factor weighs against the imposition of a preliminary injunction. So that means they couldn't prove any of the 4 things you need. So they went 0 for 4. And the court is going to address this. So let's go down to irreparable harm, which is the first thing. This is the most important thing. Irreparable harm, as the name suggests, is harm that cannot be undone, such as by an award of compensation or damages or otherwise. The 10th Circuit has held a demonstration that the probable irreparable harm is the single most important factor in considering a preliminary injunction. Consequently, the moving party must first demonstrate such an injury is likely before other requirements of the issuance of an injunction would be considered. So if they fail here, they fail. All right. So let's go on here. The court will therefore begin its analysis by evaluating the potential irreparable harm to the plaintiff. To demonstrate irreparable harm, the plaintiffs must show a significant risk that they will experience harm that cannot be compensated after the fact by monetary damages. And then it's going to go on to reference a bunch of cases, Purdue Pharma, Apple, just a bunch of them. Most of these are just cases that they're referencing. So plaintiffs claim to have already suffered and continue to suffer irreparable harm from price erosion, loss of market share, harm to its reputation, and a loss of business opportunity without requesting a preliminary injunction. In examination, irreparable harm, the court will address the loss of business opportunities, price erosion, loss of market share, and reputational harm. So let's go ahead and talk about the loss of business opportunity. Plaintiffs argue that the risk of irreparable harm is heightened because of the durable, long-lasting nature of the product in question, where an individual gun owner likely only needs to buy one trigger product for the life of his or her rifle, which can survive generations. Defendants contend that product's durability underscores the reality. Any lost sales would be fully compensatable by lost profit monetary damages. So basically what Partisan they took the rare breed argument, they twisted it and threw it back on them, which was pretty cool. Just don't look live and righteous like that. The court finds a demonstration of loss of business opportunity is sufficient to independently establish irreparable harm. During the hearing, plaintiffs argued the defendant's own self-projections demonstrate plaintiff's loss of business opportunity. Specifically, defendants' projections anticipate they will sell more than $1.68 million million triggers over the next 3 years. Plaintiffs argue that each trigger sold by the defendant will result in a loss of sale. Even a partisan lost, I would never buy a rear trigger. Just the way it is. Plaintiffs offer testimony that they collect approximately $350 profit on each trigger sold, and they would allegedly lose over $500 million in profits based on the defendant's own projection. However, loss of sales standing alone are insufficient to prove irreparable harm. So basically, you can't use that. You have to have more than just that. Without more, loss of sales are presumed to be compensated by through damages. We're going to get into that. Maybe Hoffman didn't get his because they didn't think he would be able to pay him back. so they do not require injunctive release. So basically, Hoffman, they filed right away before he started selling. So the status quo would be him not selling, and then Partisan has enough money to pay them money if they lose, where Hoffman probably didn't. Consequently, no amount of loss of revenue alone may support findings of irreparable harm. Now the court considers price erosion on the basis for irreparable harm. Price erosion refers to the theory of lost profit remedy that measures the difference between what an item could have sold for with patent protection and what it actually sold for while having to compete against an infringing item. The plaintiff suggests entry into the FRT market will lead to price erosion because the defendant's $300 trigger is 33% less than their $450 price point. Plaintiffs again look to the declaration of Dr. Warty, who stated, once a buyer internalizes a lower reference price, firms may find it difficult to return to the price level without losing sales, suggesting price erosion can lead to irreparable harm in a given market. While plaintiff's argument, including Dr. Warty's declaration, correctly identifies price erosion as a potential source of irreparable harm, plaintiffs only offer conclusory statements in support of their premise. So basically, they didn't prove their case here. Plaintiffs allude to price discrepancies between the two products at issue here, but have not offered any evidence that they have or will be forced to drop their prices. So they're like, hey, you didn't drop your prices, so what's the point? Any projections or analysis on potential price erosion or harm to the business, the plaintiffs stated quantifiable loss of sales it will suffer if not granted injunctive release does not consider the harm identified by Dr. Warty's addressing of price erosion. So they didn't drop any of their prices. So because they didn't drop any of their prices, the whole entire price erosion theory goes out the window because they never dropped their prices. While plaintiffs mentioned that the current price of $450 is 33% higher than the defendant's price point, they failed to indicate whether this price point has been a statistic or whether it's already suffered from price erosion. Aside from the cursory statements made in the hearing, no assertions have been made evidencing injury suffered from price erosion. Moreover, no evidence of the plaintiff's sales data before or after the defendant's entry into the FRT market has been presented, and no future projections have been provided. So they didn't give any information. So he's going to go into why that's all bad and they didn't prove their case. So let me just jump down here. Further, the plaintiffs have not adequately rebutted defendant's assertion that price erosion is calculable and addressable by monetary damages. So Partisan said, hey, even if that's true, we can make it right by money. And the plaintiffs didn't say anything. Defendants argue if plaintiffs are successful at trial, then economic harm from price erosion can be addressed. So basically saying, hey, if they win, we'll make it right. So right there, they lost on that one. Let's see, loss of market share. Next, plaintiffs next argue permanent market displacement in the market cannot be resolved after the fact. Their experts assert market share influences dealer attention, customer awareness, and expectations about which products are likely to remain available and supported, which is a dumbass reason because if they get it, then they're going to be the only ones. When substitution persists over time, these secondary effects can reshape the incumbent's competitive position in ways that are not reversed by a simple later legal outcome. Defendants counter in the event the plaintiffs prevail at trial and obtained a preliminary injunction, according to their own experts' description of the markets, plaintiffs will be able to quickly recapture all sales going forward. Sorry if it's noisy. The court finds consideration of loss of market share weighs against granting such relief. So basically, they're saying that, that they're full of BS. That if Partisan goes out of business because Rare Breed can successfully sue them, they can recover their market share because there'd be no one to compete against if Reverie wins all these cases. Plaintiff claims defendants undercutting RBT price by itself harms RBT's reputation by incorrectly suggesting that customers the RBG pricing is uncompetitive. Maybe because it is. At least that's my opinion. Especially we can make a better trigger cheaper, in my opinion. They also mentioned defendants' alleged attempts to label RPT as a greedy bully in online forums. What they're talking about there is all the posts on ARFCOM. When referring to the apparently quantifiable damages, plaintiffs argue that even when a permanent injunction is issued and price erosion is no longer a factor, the prevailing party still suffers irreparable harm. Defendants claim any assertion of reputational harm is conclusory and speculative. They argued that there is no claim that customers will be confused by the two products. If plaintiff products are superior, they will enjoy whatever reputational advantages flows their form. Defendants conclude plaintiffs are not based or repudiate harm on their products simply receiving less favorable market reception than its competitors. So basically saying build a better trigger if you want better reviews. In this context, proving irreparable harm does not require showing any element required to prove defamation. Defamation is totally different. Defamation is false statement made on purpose to defame someone. Rather than evidence of false statements and publication to third parties, the moving party must offer evidence of reputational loss stemming from underlying tort, altering how customers perceive the product and making the resulting harm persistent and difficult to quantify. I think Reverie did the damage themselves. Here, the plaintiff represented insufficient evidence of price erosion and loss of market share, while the plaintiffs have provided evidence of the publication of allegedly false statements online. The threshold inquiry for this equitable consideration is whether the harm ultimately stems from the patent infringement or false markings in advertising. Plaintiffs have presented evidence, defendants' negative online statements about their business and price points. They've presented no evidence of how these statements have impacted public perception of their brand. And more directly, any defamatory damages to plaintiffs is irrelevant to this consideration without demonstrating reputational harm flows from the underlying tort alleged. Okay. Sorry, oh, here it is. The variation of price points between the two products could represent a basis for reputational harm, as plaintiffs suggested, but they have included no evidence to indicating their reputation has been or will intimately be damaged. Speculative harm is not sufficient. So that was all denied because of that. Likelihood to succeed on the merits of the case. This is where we get, this is the big one, right? Plaintiffs include claims for patent infringement and false advertising as the basis for the injunction. In seeking a TRO or preliminary injunction, the movement bears the burden of demonstrating a likelihood to succeed on the merits of the case. Specifically, as to the first claim, it must demonstrate in light of the previous assumptions that the burden will apply at trial. The patentee will likely prove the accused infringer infringes on the asserted patent, and the patentee's infringement claim will likely withstand the accuser's infringer's challenges to the validity enforcement of the patent. The court should not issue a preliminary injunction if the accused infringer raises a substantial question as to either the infringement or the validity of the patent. Second, to demonstrate a reasonable likelihood to succeed on its false advertising claim under the Lanham Act, The plaintiffs must establish the defendant presented false or misleading descriptions or the representation of their product. The court finds the plaintiffs have not demonstrated they are likely to be successful on the merits of their claims, and the court will first address the claim of patent infringement and false advertising. So this judge ain't really buying that it's infringing. A party establishes infringement in one of two ways: literal infringement of the claim language, or infringement under the doctrine of equivalence. Literal infringement occurs where the allegedly infringing device includes each and every limitation of its asserted claims. Infringement under the doctrine of equivalence occurs when the alleged infringing device performs substantially the same function and substantially the same way to obtain the same result as the patented product. To establish likelihood of success on the patent infringement claim, the plaintiffs must show that the accused product likely infringes on at least one patent. This analysis entails two steps. The first step is determining the meaning and scope of the patent claims asserted to be infringed. The second step is to compare the properly construed claims to the device accused of infringing. Plaintiffs fail to meet the burden in two ways. The material claims construction disputes precludes a finding of likely infringement, and the defendants have raised serious substantial questions regarding the validity. Basically, this judge is not too sure that the patents are valid. The court will address the claim constructions and the validity instructions. The validity, the number two, is what I'm really, really waiting for. For claim construction, the court must analyze the text of the patent and its associated public record, apply and establish rules of construction, arrive at the true and consistent scope of the patent's owner's rights, given legal effect. The Federal Circuit has made it clear the interpretation and construction of patent claims is a matter of law exclusively for the court. Thus, where the parties present competing interpretations of the scope, the courts must resolve any fundamental dispute before proceeding with a patent infringement analysis. The text of the patent, the 003, the 336, 807, and 807 patents are related and share common specifications, as the 336 and 807 patents are continuations of the 003 patents. These patents all describe and claim a device similar to that of the 223 patents, with an additional feature that it provides a 3-position trigger mechanism having safe, standard semi-automatic, and force reset semi-automatic positions. So we're going to skip all that. Defendants state the patents themselves define the set position as the state, whereas the sear and the sear catch are engaged and set into position of the hammer and trigger member and are out of engagement in said release position of said hammer and trigger member. Going down here. Yeah, that's basically what he said. Claims are generally given their ordinary and customary meaning, meaning that they would have to a person of ordinary skill in the art at the time of the invention. We cannot look at the ordinary meaning of the term in a vacuum. Rather, we must look at the ordinary meaning in the context of the written description and the prosecution history. When analyzing claim construction, courts typically rely on intrinsic evidence, including patent specifications and prosecution history. Extrinsic evidence, such as expert testimony and dictionary definitions, may also be considered. What's up, Ron Wayne? The court will not give the words of a claim their ordinary meaning. When a patentee sets out a definition and acts as his own lexicon, when a patent disavows the full scope of a claim term, either in the specific or during prosecution. To act as its own lexicon, a patentee must clearly set forth the definition of the disputed claim term, other than its plain and ordinary meaning. This avowal of the claim term comes into play where the specification makes it clear that the invention does not include a particular feature, and that feature is deemed to be outside the reach of the claims of the patent. Even though the language of the claims read without reference, specifications might be considered broad enough to encompass future questions. Here, the material disputes exist in regards to the claim terms and the central to the infringement analysis. In particular, defendants dispute the scope of the phrase substantially in battery position. Defendants claim that phrase is a timing gate for when a locking member transitions from the block to permissive, meaning it determines when the mechanism transitions from a block state to one which firing is permitted. Defendants argue this phrase has more than one interpretation when applied to the AR platform operating cycle. Plaintiffs, by contrast, treat each phase as having an obvious and straightforward meaning, as the plaintiffs do not attempt to offer an express definition from the term, nor do they address the defendant's claim of a set position in the asserted patent. So basically, he's saying the defendants basically said, this is what it is. This is the definition. And Rareberry was like, well, it could mean this. It could mean that, blah, blah, blah. Drawing on the patent specifications, plaintiffs generally state when the trigger is pulled, the hammer contacts the firing pin, therefore causing the ammunition cartridge to discharge. This discharge causes the bolt carrier to move rearward, and a lower surface of the bolt hammer pushes against the hammer, which forces the trigger to return to its reset position. After that, a locking bar prevents the trigger member from being pulled again by the user until the bolt carrier has returned to its original in battery position. Defendant's expert argues substantially in battery position could reasonably be interpreted to include meaning closed to fully in battery, versus meaning that it includes a broader band of near battery in battery positions during forward travel. He continues, the phrase also raises a second critical ambiguity. Whether the claim requires the bolt carrier contact unlocking to occur at the moment that the carrier reaches the substantially in battery condition, a narrow dimensional timing window, or when unlocking earlier would suffice so long as the carrier becomes substantially in battery, relying in part on the asserted claims repeated requirements for the bolt carrier to reach a substantially in battery position. He concludes the meaning of the phrase is both disputed and potentially outcome determinative. Neither the plaintiff nor the experts attempt to express the definition of substantially in battery position as relevant to the disputed claim. Plaintiff's expert states the trigger described in the asserted patent and the rare breed trigger operates by the trigger being forcibly pushed into a reset position with the sear engaging the hammer each time the action cycles. He goes on, another shot cannot be fired until the bolt returns to the in battery position and the trigger is pulled again. The plaintiffs essentially refrain from providing a direct rebuttal to this disputed term and mechanics presented by the defendants. They didn't push back against that. However, depending on how substantially in battery is constructed, the timing requirements of the claims change because infringement analysis depends on the court first resolving the disputed claim, substantially in battery. The court cannot properly compare the asserted claim to the accused device without first construing the meaning and scope. The court finds there is insufficient evidence presented to properly make the comparison between the two products. Accordingly, the plaintiffs cannot demonstrate literal infringement or infringement under the doctrine of equivalence, nor a clear likelihood to succeed on the merits at this stage. But then it goes further. Nonetheless, the court will proceed to address the validity of the patents, demonstrating the likelihood to succeed on the merits of the infringement case. All right. So basically, the judge is basically saying, I don't have to go any further than this. You failed at this step. We don't have to go to step 2 because you gotta win on step 1 and step 2. You failed at step 1, but I'm just gonna do step 2 anyway. At this preliminary injunction stage, the court does not resolve the validity question, but instead assesses the persuasiveness of the party's evidence, recognizing that it is doing so without all evidence that may come out at trial. So basically, it said, this is what I think from what you guys showed me. If you guys have more evidence, I might change my mind. Patents enjoy a statutory presumption of validity, first to file. If the alleged infringer responds to a preliminary injunction motion by launching an attack on the validity of the patent, the burden is on the challenger to come forward with evidence of invalidity, just as it would be at trial. The patentee, to avoid a conclusion that is unable to show a likelihood of the success, then the burden of responding to the contrary evidence, which of course may include analysis and argument. Although invalidity must be proven at trial by a clear and convincing evidence, the evidentiary standard does not apply at the preliminary injunction stage. Thus, if the challenger presents evidence raising a substantial question of the validity of the patentees, and the patentees cannot demonstrate its lack of substantial merit, the patentee has not demonstrated a likelihood to succeed on the merits of warranting a preliminary injunction. Here, the plaintiffs are shown that they are likely to withstand the defendant's invalidity challenge. Have not shown that they're likely to withstand it. The court will address the defendant's theory supporting the invalidity of the plaintiff's patents and the plaintiffs to overcome. Then it goes into some law. A patent composed of several elements is not proved obvious by demonstrating that each of the elements was independently known in the art. Rather, the appropriate inquiry is whether the subject matter would have been obvious to a person of ordinary skill in the art at the time of the asserted invention. Although an incentive to combine prior art references may be inferred from the nature of the problem to be solved, there must be some articulated reasoning with some rational underpinning to support the legal conclusion of obviousness. The courts find the defendants have raised a substantial question of validity. Defendant's validity challenge rests on a multi-layer obviousness theory grounded in, and it gives you some legalese there. They contend that the 067 patent and the TACCOM 3MR long predate the asserted patent and disclose the same core force reset architecture embodied in the asserted claim. They argue the long-standing prior art references the claimed locking and gating features. The asserted patents merely combine these familiar elements in a predictable way. Defendants contend that the prosecution histories also reflect limited consideration by the Patents Office of this prior art, including the TACCOM 3MR and the 067 patent. The defendants find the evidence that the 067 patents in their prior art analysis with added support through expert declaration is sufficient to meet this standard. Once the defendants have raised a substantial question of validity, the burden shifts back to the plaintiffs to demonstrate the asserted validity defense lacks substantial merit. The plaintiffs have not carried their burden. The plaintiffs raised numerous contentions in their closing statement, including the non-existence of defendant's expert claim charts and alleged proof that the 067 patent looked at and was considered by the patent office. All of these arguments call into question some of the defendant's arguments. They failed to demonstrate the defendant's validity challenge lacks substantial merit. Additionally, contrary to the plaintiff's argument, the defendants needs only to raise a substantial question of the validity at this stage and do not need to prove their invalidity by clear and convincing evidence. Material claim constructions disputes preclude the findings of likely infringement. The defendants have raised substantial questions regarding the validity. Collectively, the plaintiffs have failed to meet the burden to demonstrate a likelihood to succeed on the merits for patent infringement. Now the court turns to false advertising. Now they're going to go to the Lanham Act. Under the Lanham Act, the plaintiffs must show the defendants made false or misleading representations by demonstrating a statement of either factually false or likely to have an effect on misleading customers. Then it goes into some of the whatever. The plaintiff asserted two bases for their false advertising claim against the defendants. First, the plaintiff state defendants falsely represented the partisan trigger as an assisted reset trigger instead of a forced reset trigger. They assert that the label are mutually exclusive and explain two triggers are designed to operate different ways. Whereas force reset triggers use mechanism to fully reset the trigger, an assisted reset trigger only partially resets the trigger. Second, the plaintiff argued that the partisan incorrectly claims that the disruptor is covered by 067, on which the partisan employs Michael Stakes, the named inventor. They contend that this representation is likely to mislead customers by falsely increasing the perceived legitimacy of the product. The defendants claim they have not made any false or misleading representations. Defendants rely on their experts and Michael Stakes, or Mr. Stakes, in practice and in literature. Assisted reset and forced resets are used synonymously to describe the same class of mechanism. The difference is semantics, not mechanics. Given the context, they conclude no false representation has been made. The defendants rebut the plaintiff's second contention by stating the disruptor is in exact compliance with Claim 19 of 067 and claim that this conclusion is supported by specific measurements and distances outlined by Mr. Stakes and Mr. Nixon. They argue the plaintiff's expert offers only a bare, unsupported assertion. On the contrary, he discloses no measurements, photographs, or analysis. The court finds the plaintiffs have not demonstrated the likelihood to succeed on their false advertising claim. The court holds that defense have presented adequate counter-analysis to bar establishment of facial falsity. In considering the defendant's representations are misleading, the plaintiffs have not presented any evidence of actual influence the defendant's representations on the consumer, such as showing the required absence of demonstrable facial falsity. According to the courts, the plaintiffs have not sufficiently demonstrated a likelihood to succeed on the merits of the case. The balance of harm element largely entails inventory and reputable harm as outlined above. Plaintiffs argue that the defendant's action is in selling the alleging infringing products are contrary to law and they cannot suffer any legally consubstantiable harm for the requested relief. Plaintiffs have also asserted because Partisan Triggers have procured patent insurance, the defendants are at minimum risk of any harm from preliminary injunctions. They conclude the balance of equities fall in favor of their equitable relief. The defendants contend that the injunction would force the company out of business. They claim an injunction would put dozens of employees out of work, create a consubstantial havoc to various people who are working in the defendant's business. Even with a sizable bond, the damages to the defendants would be indeed extreme and irreparable. Conversely, the defendants assert even in the event that the plaintiff prevail in their claim at trial, they can be made whole by monetary damages. And if the plaintiffs do not prevail in trial, the only hardship to the plaintiffs is lawful competition in the marketplace. The court finds the balance of hardship in favor of the defendants. The court acknowledges a record showing that the infringers will be put out of business is a factor, but does not control the balance of hardship. Despite this, the requested remedy is extreme. The court finds the absence of evidence demonstrating irreparable harm lightens the plaintiff's proverbial scale, shifting the balance in favor of the defendant. The court additionally notes claims related to the defendant's patent's insurance and potentially lessens any concerns about the defendant's ability to pay prospective damages. And the public interest factor requires the court to focus on whether there are existing critical public interests that would be injured by granting preliminary relief. Typically, a patent infringement case, although exists a public interest in protecting the rights secured by a valid patent, the focus of the district court's public interest analysis should be whether there's existence of some critical public interest that would be injured by granting a preliminary relief. That's another thing. The ATF weighed in on the Atrius case. I don't know how they're going to take that, but plaintiffs argue permitting the defendants to flood the market with the accused three-position force reset trigger severely reduces price and serves no legitimate public interest and only contradicts public safety. So basically, they're quoting the ATF there. Love it. They state the DOJ under President Trump has permitted Rare Breed to market the trigger on the condition that Rare Breed enforces its patents, prevents infringement that could threaten public safety, and to promote a safe and responsible product. The defendants counter due to lack of competition in the FRT market. Plaintiffs have been able to charge the public monopolistic prices for the triggers and essentially use the additional profits to continue fueling their litigation campaigns. They conclude the public interest is not served by such tactics and above market prices, but instead it would better serve by competition. After hearing, the plaintiffs filed a supplement to their requested attached Eastern District, blah, blah, blah. That's they're talking about like the Hoffman preliminary injunction. The Hoffman case involves ABC patent 247 and ABC's now expired patent 723. There, the defendants were accused of infringing on 3 patents listed, digitally releasing free firearms related designs and 3D print files for the public to download. The government filed a statement of interest in the case. That's what I was talking about. I said Atrius, but Hoffman, because the ATF filed a statement of interest in the Hoffman case, stating that it would be for public safety if Rare Breed won. Hoffman is factually distinguishable from the present facts. Here, the defendants note that the DOJ entered a statement of interest in the Hoffman case, but not in the current litigation. The Hoffman case also found the defendants' unrestricted distribution of 50/50 files resulted in what would continue as a result of widespread copying, third-party manufacturing, and uncontrolled download infringement. But as mentioned, Hoffman defendants posted the alleged infringing fireworks design online for free public access. Because they are freely distributing infringing designs rather than charging customers for an allegedly infringing product, this act had the effect of potentially stifling plaintiff's business and also expanding infringement to potentially countless individuals. The court correctly concluded the underlying facts prevented potentially irreparable harm and public safety and patent infringement concerns. Here, the plaintiffs failed to demonstrate that the current facts presented the same public safety and patent infringement concerns. In this case, different patents are at the time, and defendants have raised a substantial question of validity. Plaintiffs failed to directly adequately address defendants' validity and claim construction challenges. The defendants claim any damages could be resolved through compensatory damages. The court finds the public interest will not be highly impacted if the injunction is granted against the plaintiff. The court acknowledges that the public interest favors enforcement of protection patent rights, but the plaintiffs have not demonstrated irreparable harm and harm will result if the requested relief is not granted. Overall, the court finds the public interest does not weigh in favor of granting injunctive relief. I read like 8 times faster in my head than I do online, so that's why I don't out loud. I'm like 3 pages ahead. The court finds plaintiffs have failed to carry the burden of showing irreparable harm in the absence of the requested preliminary injunction. The parties shall proceed under the status quo while the case proceeds on the merits. The findings and conclusions set therein do not constitute determination of the merits of the finding, but made in light of the requested preliminary injunction. And now it is ordered. So everything is denied. So what does this mean? This is a huge win for Partisan. This is a blowout. I mean, this is a ass whooping. Like a 55-gallon of whoop ass was just whooping on Rare Breed by the guys who were Peak Tactical, Partisan Triggers. The judge seemed really skeptical of the validity of the Rare Breed patents, which might not be good for Rare Breed. So, yeah, I do need Hooked on Phonics. I read like, okay, so when I read really fast. I read like a book every day and a half to 2 days. And so when I try to read out loud, I read slow, so my mind start wandering other places, and I start like doing other stuff on my mind. You know, autism and ADHD together is the bitch, but whatever. But the judge seems very, very skeptical of the Rare Breed patent. So we're gonna have to see. This is not on the merits of the case, but yeah. Okay, so we had a question, and this is a good question. What does this mean for the DOJ agreement? Well, the DOJ agreement didn't say that they had to win. They just have to fight back. But I don't think that they're suing people because of the DOJ thing. I think they would have sued, and we have actually seen this with other places because this is not their first patent lawsuit. They were getting into patent lawsuits before they got into the agreement with the DOJ. So I don't think that it is. Yeah. So I don't think that agreement is why they're suing people. I think in my opinion, they're suing people because they want to corner the market and they want to have a monopoly. You don't know, it costs them $100 to make a trigger. Bipartisan trigger comes tomorrow, by the way. It costs $100 to make a trigger, and they sell it for like $450. So that is a $350 profit, which is a lot. With Partisan Triggers, they make a similar trigger. I don't think it's the same as a Rare Breed. It's more of the Tacon 3MR style, but Partisan sells theirs for under $300. So that is competition. If you get rid of fake monopolies, then prices do come down because there's competitions and people find a way to make it cheaper and better. And that is the beauty of capitalism. It drives prices down and it drives the quality of prices up while letting people make a profit. So that's basically it. This is a win. I know Rare Breed is probably not too happy with this because the judge seemed extremely skeptical of their claims. But when it goes to court, maybe they can present evidence that will sway the judge. But right now, it's not looking good for them. I do believe that Partisan has the better attorneys and the better expert witnesses, and just overall, they have a better case. And it's going to show you that they have a better case, and it's going to show you that they have better attorneys and better expert witnesses. I don't think that Rare Breed would have taken this fight if they known how hard Partisan was going to fight, or the way they're going to fight, or how much money that they had to fight back. Um, I mean, I love these nuts guys, but they don't have the deep pockets like Partisan does. I love Tim Hoffman, but he doesn't have the deep pockets that Partisan. Atreus Atreus have some deep pockets, but not like the Partisan guys. So if their patents are ruled invalid in this case, that would F them up in all the other cases. Yeah. Rare Breed has deep pockets and backed up. But yeah, so it's definitely interesting, and this is this is a this is a win. The judge also explains why he believes that the TRO was put against Hoffman, and that the judge actually Ken Hoffman challenged his injunction based on this denial. Well, the judge kind of addressed it, and it's a different type of case because the files are for free on Hoffman's site, and the ATF weighed in on the balance of harm, so and the irreparable harm clause. So I'm sure if I was Hoffman, I would appeal the injunction and then reference the file for like a writ of supplemental authority and put that in there. And so it's not going to help them. But if you file like a brief of supplemental authority, that does give the judge in the court something else to look at. So we'll have to see exactly what happens there. I just want to say Hoffman does have a GoFundMe, and I'm going to link that not GoFundMe, sorry, Gibson Go. I'm going to link that Gibson Go right now, just so if you guys want to give some money to Hoffman, you can go ahead and do that, because he's gonna need all the help because it's expensive. Oh, he's almost at 78,000. He's almost at 79,000 or $69,000. Almost 70,000. You should break 70,000 tonight. All right, guys. Well, I'm gonna get out of here. You guys enjoy your weekend, and yeah, have fun. Bye.